We now come to the next item of business, is the Reform Legal Aid. Can we please leave quietly and quickly? So just we now start the debate. I now call Yvonne Farage to speak.
Thank you, Mr. Speaker. I'd like to thank the Backbench Committee for agreeing that this important topic be debated prior to the closure of the consultation on the proposals for the reform of legal aid in England and Wales. The consultation paper proposes to cuts to an estimated total of about £350 million from the civil legal aid budget. Roughly 2/3 of these cuts are directed at those people who are currently legally aidable, and 1/3 is to come from remuneration cuts to providers who are expected to do the same work but for less money. £279 million is being cut from civil legal aid. Around 500,000 people are going to lose their entitlement to legal aid. The majority of these come from low-income households, and the Ministry's own equality impact assessment acknowledges that these will be predominantly women, black and minority ethnic people, and ill and disabled people. However, whilst the consultation acknowledges this, it also says it's not just about cost. It's the right thing to do. I believe that I can demonstrate that both the cost argument and the statement that it is the right thing to do are both incorrect. And in fact, the implementation of these proposals to reduce the civil legal aid will hit the poorest hardest, it'll increase the cost to other public bodies, and it'll have a potentially catastrophic effect on advice agencies, not-for-profit advice agencies, including citizens' advice bureaus and law centres.
Would my honourable friend give way?
I'll give way.
I'm most grateful to my honourable friend, and I congratulate her on securing this debate. Does she not agree that one of the issues that ought to be addressed is the issue of poor decision-making by public authorities? In particular, for example, in the immigration field, where the UK Border Agency fails to make good decisions based on good evidence. And that is why people have to go to the tribunal, and that is why they need legal aid.
I thank my honourable friend for that comment, and indeed it is a comment I am coming to later when I do suggest some ways of saving money in the system. Whole swathes of advice areas are removed from scope, particularly the social welfare law category. Welfare benefits is removed completely from legal aid. Now, on the Ministry of Justice's own equality impact assessment, 63% of clients who received legal aid in this category had a disability. 54% are female, and 27% from a black and minority ethnic background. However, this is justified by stating that the accessible, inquisitorial and user-friendly nature of the tribunal means appellants can generally present their case without any assistance. It also states advice and help are available from a number of sources, including Job Centre Plus and the Benefits Enquiry Line. So people who've had their claim refused by Job Centre Plus or the Benefits Agency are to go to them for support in challenging a decision, and they'll help them. I have to say, that is not the experience I had when I worked for an advice agency. I will give way.
Friends giving way, and on the basis of what my honourable friend has just said, which I support entirely, would my honourable friend be interested to know that the Brighton Housing Trust Eastbourne Advice Centre deals with at least 800 specialist housing cases per year, and they anticipate this would fall to approximately 100. Are they really expecting, or are we really expecting Job Centre Plus to take up the slack? What would my honourable friend have to say?
My honourable member, that intervention. And yes, I totally agree with him. In fact, my local Citizens Advice Bureau has rung 100 times to the Benefits Agency and has had no response apart from saying everyone is busy. These issues are also not considered of a sufficiently high importance. Well, when a person is ill or has a disability, one of their major concerns is having an adequate income to enable a decent quality of life. The early advice available under this funding can actually save money. 80% of social welfare legal aid cases have positive outcomes for clients, and in the agency that I worked, 70% of our reassessment appeals were successful, and that negated the need for a costly tribunal. I'd also like to debunk the myth that these cases aren't complex. My own CAB in Wigan dealt with a case for 3 years where the DWP asserted that a couple were living together as man and wife, despite evidence from a neighbouring local authority that Mr M was resident there and receiving benefits, and that he merely visited to look after his disabled daughter, assisting with her care on occasions. Mrs M was summoned for benefit fraud, convicted, and ordered to repay £27,000. The Bureau continued with the case, appealed 3 times, went to the Secretary of State, and at the final appeal, Mrs M was found to owe £236, a reduction of over £26,500. And that wasn't a complex case, and that case would be suitable for a telephone helpline. I don't think so. I think that client needed the face-to-face help given by a skilled CAB advisor and was funded by Legal Help. I'll give way.
I thank my honourable friend for giving way and congratulate her on securing this debate. Does my honourable friend agree that the suggestion that legal advice could be provided over the phone fails to understand the level of support that's provided by many legal representatives, particularly when they're dealing with vulnerable groups and potentially when they're dealing with asylum and refugees, often people who face persecution, who are separated from their family and perhaps don't have English as first language?
Honourable friend for that intervention, and I totally agree with her. When people are at a time of stress, they do need the support, quite often, of a friendly face. I'd like to continue by saying for every £1 in legal aid expenditure on welfare benefits in the Wigan Borough, £20.50 of additional benefit per year is obtained for clients. And nationally, for every £1 of legal aid expenditure on welfare benefit, the state potentially saves £8.80. I'd like to move on to debt now. I'd just like to make a little bit of progress. I'm afraid the debate is quite late. I'd like to move on to debt, another area removed from scope, except for cases where the client's home is at immediate risk. The impact assessment shows that 55% of debt clients are female, 30% are likely to have a disability, and yet again, the consultation paper believes that although the debt problems are important to the individual, they're not important enough to warrant legal aid funding. However, I have myself seen the effects of debt on individuals and the cost, both human and to the state, including the NHS, of not resolving debt issues at an early stage. A project that I was involved with personally used a recognised NHS scale to monitor stress levels before and after the advice process that dealt with unsecured debts. And our local PCT believed that in the first 9 months of the project, 3 suicides had been prevented. At what cost? In Wigan, my CAB deals with 616 debt clients per year at a cost of £123,000 to the state. They reschedule £4.83 million worth of debt and they write off £3.47 million. Potentially, for this amount of expenditure, £367,000 is saved by spending £123,000. Now, I totally support the expansion of financial education into schools and communities, but this won't assist people who are in debt now. In fact, it's my experience when the issue is raised in schools, more parents arrived at the advice agency's door as they're aware that there's somewhere to go, and they almost feel they've got permission to go there.
Would my honourable friend just give way on that?
I will give way.
I thank my honourable friend. Every conscientious MP will know the value of citizens' advice bureaus, because otherwise our offices would quite simply be swamped, and that prospect awaits us. My honourable friend has highlighted Wigan. In Stoke-on-Trent, the citizens' advice bureau has highlighted that there will be 730 fewer people who will get specialist debt advice. A total of 1,280 people will not get any advice at all. Newcastle-under-Lyme, my area, will be on top of that. Over 1,500 people in North Staffordshire. Would she agree that this is not only a false economy, but really it's a heartless cut as well?
thank my honourable friend for that intervention. I completely agree with him. And I will go on to some figures I have on the impact it will have on advice agencies. Agencies providing telephone advice, such as National Deadline, have got a great role to play, but they can't replace face-to-face advice, as my honourable friend mentioned before. The reality is people need to sit down with an advisor, and they need the reassurance and the trust from a relationship that is built up over time. There was a reason that the social welfare law group of problems, including employment, housing, debt and benefit, were primarily given to advice agencies, and that's the interlinking of the problems. Limiting the scope and the type of problems that the advisors can deal with limits their ability to deal with the whole person and all their issues. For example, the legal help might prevent someone losing a home because of debt, but it won't address the causes of that debt, such as unfair dismissal or a refusal of sickness benefits. I could continue to give many examples of other areas that are taken out of scope, but I believe some colleagues, honourable friends, will be also mentioning those. The list is extremely long. Access for the most vulnerable is excluded and severely curtailed in many cases. I turn to the effect on Citizens Advice Bureau and the not-for-profit providers. The Ministry itself estimates that this sector will lose 97% of its legal aid funding. Currently, Citizens Advice Bureau, local Citizens Advice Bureau, receive £26 million of legal aid funding, with debt and benefits being the largest amounts. If these proposals are implemented, then £20 million will go in one fell swoop. There won't only be a significant impact on the ability to deliver legally aidable services, but also on all the other client services. There was a survey undertaken by the National Citizens Advice that showed if the proposals went ahead, 80% of your local bureaus, the honourable members' local bureaus, would have to withdraw specialist services. 85% would have reduced capacity to meet clients' needs, and, most shockingly, 51%, over half, felt there would be a risk to the continuation of the whole CAB service in their borough. Legal aid funding can't be treated in isolation from other sources of advice funding, especially as the consultation assumes that people can access the other services to pick up the slack. The free advice sector is suffering disproportionately from public funding reductions, and even agencies such as the RNIB, who have no legal aid funding, have approached me, telling me they can't deal with any increase in demand for their services due to the impact of the proposals. I will give way.
And she's making an eloquent case, particularly on behalf of organisations which are currently giving evidence to the Justice Committee on just these matters. But does she recognise that there may be some scope, and ought to be some scope, for looking at some of the sources of some of the problems on which this advice is being sought to provide the funding, whether it's public bodies who make poor decisions, as our honourable friend rightly pointed out, or indeed the banks?
I thank the honourable member for the intervention, and I totally agree there is scope for other funding provision. However, that hasn't been available up to yet, and in fact, provision is being withdrawn with the face-to-face funding going from Citizens Advice Bureau now.
Well, my honourable friend, wouldn't she also accept that, of course, need is rising in the present economic climate, need particularly in relation to employment, to social welfare benefits and to debt?
I completely agree, and thank you for the intervention. I thank my honourable friend. I completely agree. This is a time of great change for many of our clients, and the need for legal help is even more vital. I'll now move to the suggested resolution, the Community Legal Advice Helpline, the gateway to civil legal aid services, and the body that will offer non-eligible clients access to paid services. Firstly, I want to take issue with the premise that the legal aid scheme has expanded beyond its original intentions. Actually, the Legal Aid Act 1949 was promoted with very wide objectives that were explained to the other place, and I quote, "Legal advice for those of slender means and resources, so that no one will be financially unable to prosecute a just and reasonable claim or defend a legal right." I'm not convinced that a gatekeeping telephone helpline will promote this. Access to telephone advice is important, and I would welcome any expansion, but it has to be implemented in tandem with face-to-face services. Clients need to have that choice. The CLA helpline uses an 0845 prefix, which is very expensive from a pay-as-you-go mobile. Many people with learning disabilities or mental health issues prefer to attend in person, to pick up on non-verbal signals and to build the trust necessary to tell the advisors their problem. CAB make a particular effort to reflect the community they serve, and this is why people go to their services. As an aside, I would like to mention volunteers, another place where people can pick up the advice in the consultation paper. There may be an assumption it can be picked up by volunteers, and I don't believe this is the case. Volunteers work best and most confidently, supported and encouraged by specialists, and it's only when this support was provided that the number of volunteers and the depth of the work they undertook increased significantly in the Bureau that I managed. There are opportunities to save money in the justice sector without placing the burden on frontline services. The Ministry of Justice intends to reform the Legal Services Commission, and there is a large amount of bureaucracy in the administration of legal aid. I have to say, I spent 60% of my time managing 30% of the money I got. A lighter touch procurement and auditing and payment mechanism could be found, and I think this needs to be looked at seriously.
Would my honourable friend give way?
I will give way.
Just on the point of volunteers, I'm grateful to my honourable friend for giving way. I wonder whether you'd agree with this. Many of my colleagues in my chambers and firms of solicitors locally volunteer their services to advice bureaus regularly, but the incidence of that is going to diminish given the dreadful cuts to legal aid to those firms and the very fact that they're not being able to take on trainees as a result of the cuts to them. The advice is diminishing drastically as a result of the cuts of this government.
I thank my honourable friend for that. And I do agree that provision of pro bono advice is important, but it's not available in all places. In fact, in the conurbation that I served, there was no pro bono advice. I will go on to say that decreasing the need for civil legal aid is also important. Again, addressing the poor decision-making by public bodies, avoiding the needs for tribunals. Take the lawyers out of tribunals. Make the legal processes simpler. Improve public legal education. Early advice saves money and it keeps cases out of the courts. The funding for this needs to be looked at instead of salami slicing and looking at what are administratively convenient categories of problems. Provision of advice needs to be organised around the real needs of people, and the person needs to be treated as an individual, not as individual problems. Access to justice is one of the cornerstones of a free and civilised society. It is vital that everyone, particularly the most vulnerable, have equal access to the law, no matter who they are, where they live, or how much money they have. This consultation proposes removing that for large numbers of the most vulnerable. Is this access to justice, or is it justice denied?
Order. The question is as on the order paper. More than 20 honourable and right honourable members have applied to speak in the debate, as a result of which I have imposed a limit of 5 minutes on each backbench contribution, and I simply remind members they're not obliged to use their full 5 minutes if they don't wish to do so. I'm keen to get everyone in, but members need to help me to help them and to help each other. Anna Soubry.
Thank you, Mr. Speaker. As you may know, and others also, I declare an interest from the outset because until my election to this place in May, I worked for 16 years as a criminal barrister in Nottingham and in other places such as Leicester and in Derby. Mr. Speaker, I'd like to begin my remarks this afternoon by saying this. I think it is important to remember that it's common ground in this place that there is a need to make cuts in public expenditure. And we've had many debates as to where the blame lies, and we could continue that. But what I would suggest this afternoon is that that really isn't very helpful. We are where we are, and certainly nobody on this side welcomes having to make these sorts of cuts, but we have one of the largest deficits, or certainly the largest deficit of any G20 country, and so it is with considerable regret that this government is placed in a position where it has no alternative but to make severe cuts in public expenditure, including legal aid, of course.
Would the Honourable Lady accept the Citizens Advice Bureau report that not only is these proposals limiting access to justice, but they're all also going to actually increase public expenditure?
I don't know about the latter point, but I do know from the work that I've had, or contact I've had with the Citizens Advice Bureau in Broxtowe, that this is an area which I'm particularly concerned about, and I've made it very clear to the Nottinghamshire County Council that in these difficult times it's imperative that they exercise great care when they are cutting back the budget of the Citizens Advice Bureau. It's something that the Prime Minister has spoken about, it's something that the Lord Chancellor has spoken about, because it's recognised that the Citizens Advice Bureaus do a magnificent job. I think every single person in this House knows the work of the Citizens Advice Bureau. Our caseload would increase enormously without them, and there is a danger that in these difficult times more cases will be going to them. It's imperative that they have the resources they need. What I would ask them, indeed.
I thank my honourable friend for giving way, and particularly on that point with the CAB. Would my honourable friend agree with me that the role that they provide in this is preventative, enabling in its nature, and is not focused on generating unnecessary litigation, is focused on preventing crises, so therefore having a properly resourced CAB actually will save money?
Good points, well made, if I may say, Mr Deputy Speaker. I'd like to make some progress, because I would... Sorry, did I say Mr Deputy Speaker? That's outrageous, Mr Speaker. I apologise, most sincerely. What I would ask the Minister to do, though, being serious if I may, is really to very carefully consider the effects of these cuts in legal aid. I think many would agree with me that it's imperative that we make sure that the most vulnerable people in our society do not suffer when we have to make these sorts of cuts. And it's also important to protect the interests of those people, those citizens who actually can't protect themselves. I'd like to give two examples, if I may, from the reductions that we made in the legal aid that goes into the family division. A father who is denied contact with his children will no longer be eligible for legal aid. I would submit, with great respect to the Minister, that that can't be right. Not just because of the father's own rights to see his children, but also, of course, of the rights of the children who have no access to justice, that their interests are protected by us, if you like, as a society. They need to see their father. My other example is this. A mother who has separated from the father of her children, and he is now threatening to take them overseas, I understand also will no longer be eligible for legal aid. And again, I would suggest that that can't be right. It's not just not fair on her, but it is equally not fair on her children, because she will not want them taken overseas, and they will again want to have contact with both their parents. Former colleagues of mine at the bar have said to me that they have many concerns, and one of those areas is within housing. Now, somebody who is living in squalid housing conditions, I think we can all assume will themselves more than likely be eligible in the past to legal aid. Now, that will continue, of course, in many circumstances, but my concern is that legal aid will no longer be available so that they can force a landlord to make the repairs. In other words, to begin to solve the problem before it becomes the source of problem, which would still remain, that person would still have the eligibility for legal aid. And I would also please ask the Minister to consider this. I'm told, I'm very grateful to my learned friend from Swindon South for this, but that we are paying £24.7 million in legal aid for welfare claims. Now, I may be wrong, of course, but just on my own time in this House, it strikes me that one of the reasons why so many people not just come to our doors with their cases, or the CAB, but also have to go to law, is because of the profound failings within the DWP. And it strikes me that one of the best things that we could do is to make sure that that department is working properly, efficiently and effectively, which would obviously save us considerable amounts of money. And Mr Speaker, I'm sure you will remember, and I found this astonishing as a new member, that we actually have MP-dedicated hotlines for our caseworkers to ring to sort out problems that frankly should never have arisen, but because of the ineffectual and lack of effectiveness within the department. And I really would urge the government to make sure that we sort that out. Yeah. Finally, Mr Speaker, in these last remaining seconds, I would make a plea for the Bar. The Bar has had no increase in fees now for decades. And yet again, the criminal bar is being asked to reduce its fees by 10%. So that if you are prosecuting counsel, prosecuting a rapist, a persistent dwelling house burglar, you'll be paid £60 as a fixed fee. Sometimes members of the criminal bar are working for less than the interpreter in court, invariably for considerably less than the medical expert who may be assisting them in their work. Mr Speaker, thank you for the opportunity to speak. I'm sure that the Minister will have heard all these points, and I look forward to the action that will come from them.
Yeah.
Thank you very much, Mr Speaker. Can I congratulate the Honourable Member for Makerfield for her introduction to this debate, and spoke with enormous clarity and mapped out a whole range of the ways in which the cuts in legal aid will impact upon our constituents. And indeed congratulate the Honourable Lady for Broxtowe, who also said a great many things that I agree with, including the fact that we must beware of labelling all lawyers as fat cats. And indeed legal aid lawyers work extremely hard for relatively modest remuneration, and I think we need to remember that. So without repeating the key points made that these cuts will represent a false economy, that there are real dangers in restricting the areas that are taken out of scope because so many cases are complex, and cases such as debt and housing run into one another and cannot be separated out, and the argument that there are limits to the value of phone advice. These are very, very important points, and I will not dwell further on them. I just want to make 3 points, really. The first is, if there was ever a time to be scaling back on legal aid, particularly in civil and social welfare law, this is not the moment. We are seeing massive upheavals in public service delivery, in education, which I'll return to in a moment, in housing, the proposals in the Localism Bill, which will introduce short-term tenancies, in welfare, where the £18 billion is being taken out of the welfare budget with the cuts in housing benefit, and all of those the changes in the disability benefits, and of course, as has been mentioned, the rise in unemployment and the broader economic context.
For the Honourable Lady giving way, but does she not accept the current cost of legal aid is unsustainable in a sense where we are spending £38 per head of population on legal aid, whereas in Australia it's £9 and in France it's £3. Therefore, these reforms are essential to get our economy back on track.
There are so many points in which I could respond to that. I don't think it is possible for us to compare systems between countries. There are so many differences in the way both the legal system and legal aid support is delivered that is not helpful. Indeed, my own front bench are willing to discuss the legal aid budget, particularly in some aspects of criminal legal aid. There are areas in which savings can be made, but I'm particularly concerned about civil and social welfare law. The second point I want to make, which was made strongly when we had a debate in the second chamber, is the impact of these cuts, the speed and the depth at which they are being made upon the services, the legal aid firms, law centres, citizens' advice bureaus and other advice agencies. Now, they are in many cases drawing on legal aid for part of their funding. The removal of legal aid funding, it's like a game of Jenga. You start pulling out the sticks and the whole edifice is in danger of collapsing. And I think we will see a massive unplanned spate of closures of services across the country, and we will not be able to control where those closures take place. There will be advice deserts, and many of our constituents will struggle as a consequence. Just to take one example of that as well, this is being delivered at the same time as the cuts in local authority spending, that the London grants the London grant scheme is being repatriated to the boroughs without ring fencing, which means that advice services in London are very much at the whim of local boroughs that are themselves under pressure, and therefore the grant funding that should complement the Legal Services Commission funding is unlikely to be there, and I think that is clearly going to impact very severely upon citizens' advice bureaus and law centres. And I think, as has been said, politicians will regret taking this decision, because I am already seeing, and I'm sure other honourable members are already seeing, people coming to us for what should be a legal advice and representation service that we are in many cases not qualified and are certainly not resourced to provide. And I predict with absolute certainty that our surgeries are going to be flooded with more and more desperate and angry people who cannot get the proper representation that they should. Just finally, Mr. Speaker, on the disproportionate impact upon women, children, people with disabilities and black and minority people of black and minority communities. We know from the areas of scope that are being affected that this will fall most heavily, these cuts will fall most heavily upon them. We've heard about the issue of family law, the issue of asylum-seeking communities, particularly asylum-seeking children who are very much left at risk because of these cuts. But just in my final few seconds, I want to make a particular case for the issue of education and special educational needs. I, in my own borough, have a particular problem of children without a school place. 350 children were without a school place before Christmas. Those children and their families need advice and representation. And those parents who are seeking to take action against their local authority for denying them a statement of special educational needs are a particularly vulnerable group. And we know from the number of tribunals that are taken and succeed that those cases that actually reached tribunal, 82% of parents' appeals are upheld. Now, to remove assistance from those parents, many of whom simply do not have the skills or the resources to make their own case, means that their children will not get the education that they are entitled to. And I urge the Minister to go back and rethink so many aspects of these proposals, but in particular the narrowness of the scope that is being applied to the legal aid cases and the arbitrary way in which those services are being withdrawn from scope.
I'd like to start by congratulating the Honourable Member for Macclesfield for opening this debate, and I think setting out her genuine concerns about the impact that some of these changes may have on her constituents. Now, I accept that as a new member, I think she, to some extent, can deny all responsibility for what came before because she wasn't a member of this House. However, I look around her at ex-ministers who know full well that had they been on this side of the House, they would have been taking the same decisions. So the tutting and the shaking of heads from ex-ministers opposite, I find intellectually extremely dishonest. That I'm very happy to give way.
Thank you. And to reinforce that point, there were no less than 30 consultations on legal aid between 2006 to 2010, which gives the lie to the fact that there is in fact a divide here. Yes. Both parties were faced with the same challenges. So let's approach this debate on that basis.
I agree
the intervention. I hope he'll confirm to me that he's not accusing any member of being personally dishonest, because we can't have that in the chamber. Mr Tom Brake.
Of course, Mr Speaker, I'm not accusing any ex-minister opposite of being personally dishonest. I thank the honourable gentleman for that intervention, and I think on both sides of the House, I think we regret the decisions that are having to be taken. However, I think it's incumbent on members on this side, ministers, to come forward with solutions. But on the other side, if they want to be taken credibly, I think there need to be solutions as well. I'll give way once more, and I think I need to proceed.
I'm grateful, but would he not agree that the solution that the present government is proposing, which is wholesale removal of significant categories of social welfare law, is actually the most damaging and unsatisfactory way to proceed?
I hope that during the course of this debate, and the Minister is listening carefully, that there may be some adjustments to what is being proposed. But I do think that what we need to hear is solutions. We don't need to hear a list of concerns which are not followed up by some solutions to a problem which we all face in this House. Now, I want to just use this as an opportunity to raise a couple of very specific points which I have written to the Minister about, and I thank him for meeting with me and my local Citizens Advice Bureau, Steve Triner and others, to discuss their concerns about these proposals. I've also recently had meetings with solicitors 3 solicitors in my constituency office, like other members on both sides of the House, a wide range of briefings from different organisations, and also a briefing yesterday from the Equal Rights Trust, where again I want to raise a specific issue. Now, the Minister, I hope, will be aware of these, as I've already written to him about a couple of the points that were raised with me. And the first point I wanted to raise was in relation to medical negligence, where clearly there is concern about the impact that the changes could have, and whether there will simply end up being a position where perhaps previously the NHS might have taken on responsibility for settling a particularly difficult, complicated medical case, and whether now, in fact, that may simply be passed over to social services for them to take on the financial costs associated with some of the most serious obstetric mistakes in relation to, for instance, brain damage in very young children. So I think that is a very specific issue which I hope the Minister will respond to. In relation to family law, in the meeting I had with solicitors, interestingly, they were not particularly concerned about the idea of a telephone helpline. What they were concerned about is what happened beyond that in terms of referrals, and if there was a process of identifying at the very beginning of that process that someone could not be dealt with through a telephone contact and a face-to-face meeting was required.
On that point,
I'm very happy to give way.
Does my honourable friend share my concerns that people with mental health issues may not get equal access to justice when they're involved in family disputes now?
I thank the honourable friend for that intervention. I think that is a very strong point. Again, one of the things that I hope ministers will be listening to in relation to this debate and the wider consultation. So in relation to family law, clearly there is, I think, rightly an encouragement to pursue mediation in relation to issues that currently end up being supported through legal aid. But a point that was made to me during this meeting was that very often government bodies and associated organisations are very unwilling themselves to pursue a route that involves mediation. So I think it will require an undertaking on the part of government and government departments and associated bodies to show a willingness to engage in mediation themselves, if that is now the direction that the government are moving in. In relation to telephone advice, I've already raised a couple of points about that, but there are concerns about whether there will be any local knowledge embedded in any telephone advisory service, how some of the conflicts of interest that may arise as a result of that, particularly if there are a limited number of suppliers to whom a case can be referred. The point that was raised by the CAB during this meeting was their concern that they would now be in a position of having to take up very personal cases and therefore would be very much in the front line rather than acting as an independent body. So they might end up having to represent one particular individual against the other party in the case, and they were worried about how this would impact their independence. They're also worried that a lot of court time would be lost, particularly if more people ended up representing themselves. So I think there's a good job to be done there in terms of making that process clearer, simpler, so that if more people do represent themselves, there is less risk that people fail to turn up with the right papers, fail to turn up on time. I'm very happy to give way one last time.
Thank you. You've said that these changes rely on people being able to help themselves, but what about people with learning difficulties? What about people with mental health problems? What about people who can't speak English very well? And what about people who are too frightened to face their opponent?
I thank the Honourable Lady for her intervention, and again I'm sure the Minister, who is sitting not very far from her, has heard those concerns and I hope will seek to address those. The final point that I'd like to make is in relation to the Financial Inclusion Fund, where the chair of my local CAB have highlighted the fact that this will close at the end of March. I understand there is proposals being looked at in terms of transitional funding, and I don't know whether the Minister can respond on that point. The final point that I wanted to make was in relation to stateless people, a point that was raised with me by the Equal Rights Trust, who are now going to be in a position where they can't claim legal aid unless they apply for asylum. So there may be some unexpected consequences of this, which the Minister, I hope, will respond to at the end of the debate. Clearly, this is a very difficult issue for government, which I know the Minister is going to do everything he can to address effectively. We do not like being in the position that we're in, but it is an issue that we have to address now.
Mr. Ben Bradshaw.
Mr. Speaker, can I begin by congratulating my honourable friend for securing this very important debate and commend her on her excellent speech. And given the welcome fact that so many members want to contribute, I will confine my remarks to the impact of the government's proposals on my local Citizens Advice Bureau in Exeter, which would mean, for Exeter Citizens Advice Bureau, losing all of its welfare benefits funding, and funding for debt cases would be restricted to instances when there is an immediate risk of homelessness. And taken together, my CAB estimate that these changes will affect up to 700 cases a year in Exeter alone. The director of Exeter CAB, Steve Barrable, has described as perverse the fact that the government is only proposing to fund debt advice when the client faces an immediate risk of homelessness. He goes on to say it is widely accepted that timely intervention, as my honourable friend said in her speech, is more productive and reduces costs elsewhere, such as county court repossessions and other action. Mr. Speaker, as other members have said, these changes represent a terrible false economy, and they come at the same time, in my case in Exeter, as the local authority, Devon County Council, is proposing to cut its support to the Citizens Advice Bureau by 20% as part of their attempts to grapple with a 27% reduction in funding from central government. And yet, it's estimated that for every £1 of public money spent on Citizens Advice Bureau services, the CAB saves the public purse £12.20. And I have to say, I'll give way to my friend.
I appreciate what he's saying about his local Citizens Advice Bureau. In Wolverhampton, the Citizens Advice Bureau does some 1,600 cases a year funded by this help, and 26 employees are involved in it. The local director has said, and I quote, "The CAB would effectively go back 20 years in its development if these proposals go through." And in response to the honourable member who spoke a few moments ago, would my right honourable friend contrast these proposals with the record of the Labour government, who increased the funding to the Citizens Advice Bureau when the recession was coming, precisely because we knew there would be a greater need for debt advice as economic times like that?
My honourable friend is exactly right, and I was coming on to make the point, gently I hope, to the honourable members, both for Broxtowe and to Carshalton and Wallington, that it's not good enough for members on the government benches to excuse every single cut this government is implementing on the need for fiscal consolidation. There is a choice to be had at the speed and the degree of fiscal consolidation, a very, very clear choice, and there's growing evidence that the speed and degree of fiscal consolidation being pursued by this government is not only damaging important services like the CAB, but is damaging our economic recovery. All honourable members need to do, sit down. All honourable members need to do is look across the Atlantic at the example of the United States under Barack Obama, who is pursuing a Keynesian economic policy as the one we advocate, where growth was 3.5% in the last quarter, as opposed to a 0.5% contraction here. So please, no more lectures from the parties opposite about there being no alternative to these savage cuts. For all the government's rhetoric, Mr. Speaker, about the big society, the CAB is the big society in action. It's staffed mainly by volunteers, helping everyone, but in particular helping the vulnerable, and saving the state millions of pounds in the process by ensuring that people in difficulty do not fall into crisis, the fallout from which the state then has to pick up. And the proposed changes by the government in legal aid and their impact on the work of CABs like mine in Exeter will have a deeply damaging impact on the fabric of our communities and will cost us all far more in the long run, and therefore I do urge the government to think again about this short-sighted and false economy.
Indeed, Mr. Paul Upward.
Thank you, Mr. Speaker. Can I also thank the Honourable Lady for Makerfield for actually bringing forward this debate, and very much in the spirit of the sentiment expressed by my honourable friend for South Swindon, I very much wanted to take part in this debate in a non-partisan way, and very much on the basis of actually trying to progress this debate. Other members will speak I've already spoken about the issues of employment, welfare benefits, education and immigration. But it is in the field of clinical negligence that I wish to express some of the views that I've encountered at my weekly surgeries. If legal aid for clinical negligence cases is removed, I note that the government's view is that alternative funding will be available in the form of conditional fee arrangements, which will be funded on the basis of a success fee and after the event insurance. Under Lord Jackson's reforms, these will be unrecoverable from the losing party. The point that has been made to me, and that I now wish to highlight to the Minister, is that if legal aid is withdrawn and cases have to be funded by conditional fee arrangements with insurance, there will be instances where the cost to the public purse may well be higher. For example, a solicitor at my surgery spoke to me about a cerebral palsy case, which settled for over £3.75 million. The costs involved were over £100,000. It was legally aided. But if it had been funded on a conditional fee arrangement with, say, a recoverable success fee of 60%, the total cost would have been £160,000. There had also been a substantial after-the-event insurance premium, which would mean that the case would have cost the public purse far more than if it had been funded by legal aid. This is the position where cases are successful and where the Legal Services Commission does not actually pay anything. I appreciate some members may not have followed the full argument of what I'm saying, and I apologise for using legal jargon. But the fundamental point remains that we may be saving legal aid costs, but we may well be ending up paying more into the National Health Service budget to cover legal fees and insurance premiums. In essence, we have public money chasing public money, in a circle which will not deliver legal justice on a value-for-money basis. The counter-argument is that if Lord Jackson's recommendations are implemented in full, there will be no increase in costs of success fees, and after-the-event insurance premiums will not be recoverable from the losing party. However, Lord Jackson has recommended that the damages be increased by 10% to make up for the shortfall in solicitors' costs, with a 25% cap to be deducted from damages. This means in the cerebral palsy case I just mentioned earlier, the damages would have increased by £375,000, which would have been an alarming escalation of public funds. I appreciate the difficulties facing the government on the escalating drain on the public purse, and I suspect many measures relate to concerns of the costs incurred by solicitors who are chasing ambulances or spuriously investigating unviable and unsuccessful cases. However, I would say to the Minister, who I know has a great deal of expertise in this field, that clinical negligence cases are now conducted by a small group of specialist solicitors who are focused in dealing with complex cases, and it is increasingly rare for solicitors to tread the old route of just applying for investigated help certificates for every client who walks through the door with a potential claim because the cases are just not viable. The Special Cases Unit of the Legal Services Commission, which is based in Brighton, does now seem to apply a robust criteria to all applications for Legal Services Commission funding to ensure that cases with merit are actually granted funding. David Keegan, Director of the High Cost Cases Unit, said, "We need to ensure that access to justice is as wide as possible and is in the best interest of our clients. The only thing I would add to that is that it must be reconciled at the most cost-effective way possible." I also think it pertinent that Lord Jackson's objective in conducting this year-long cost review was to make recommendations in order to promote access to justice. If legal aid is no longer available, the cost may be disproportionate. I'll try and wind up very quickly and get to my conclusion. I'm acutely aware of the government's laudable intentions on this issue, but I do worry about unintended consequences. The issue that has most been loudly expressed to me at this time again and again is that if we genuinely desire cost saving in this area, it is imperative that we look at NHSLA making early admissions of liability rather than protracted settlement of these cases. In a nutshell, nobody in the hospital wishes to admit negligence, and when that happens, it's a game of bluff developing, and the solicitors and the NHS conducting a legal battle which often is settled at the last minute. That is why we see headlines of cases involving liabilities claims running to tens of thousands of pounds, but legal bills of hundreds of thousands of pounds. Like most, I can't understand the logic of that. And in these cases, early settlement would avoid a pointless game of poker with our money, the emotions of patients, and the goodwill of the staff who work for the NHS.
Mr Elfyn Llwyd.
Thank you very much, Mr Speaker. Can I congratulate the Honourable Lady for Makerfield on securing time for this very important debate? And I declare an interest as a person who has in the past undertaken publicly funded work both as a solicitor and a barrister. I'm a member of the Justice Select Committee, which is very ably chaired by the Right Honourable Gentleman for Berwick-on-Tweed, and we are currently undertaking some research into this particular area. We have received unprecedented amounts of evidence from concerned groups, and I'll give voice to some of these now in the limited time available. It's my belief that the proposals set out in the Government's consultation document are unethical and will leave long-standing and drastic effects on the make-up of our legal system. They will effectively pave the way for creating a market for the supply of legal aid assistance, and I believe the quality of assistance available will decrease, with the result that the wealthiest in society will be okay and those who are not will not. And the consultation document notes with, I believe, unintended irony that, quote, access to justice is the hallmark of a civilised society, unquote. And we must do all we can to uphold this principle. And the proposed reforms will mean the legal aid market will be driven by cost rather than by the needs of clients and the quality of advice to them. And a move to fixed fees for all cases, I believe, will mean suppliers will take only the least complicated cases, which will mean the most vulnerable will more frequently go without proper legal advice. The need to generate profits will lead firms to take on unqualified staff, which in turn may well affect the quality of service provided being lower. The Gwynedd Law Society have written to me drawing attention to the fact that there's a real danger across Gwynedd and Anglesey, where over a population of about 190,000, there are only 10 firms providing civil legal aid at the moment. There are no large firms in the area, and most of these firms provide assistance in both languages, Welsh and in English. There's a great deal of concern, and the cuts to legal aid will be felt deeply by many areas of society, but the effect will be had worst, of course, on the most vulnerable, which is deeply worrying. There's a letter in today's Times which is signed by a number of experts in family law, among them Stephen Cobb QC, Chair of the Family Law Barristers Association, and also David Allison of Resolution. I can't read it into the record much as I'd like to, but I commend that letter to honourable members. Family lawyers will undoubtedly be giving up in droves, creating advice deserts, and our children will be the ones that will suffer. I do have several case studies which show that mothers, when children aren't returned to them in certain circumstances, will be able to do nothing about that under the current suggestions. And I find it very worrying that legal aid will be removed for ancillary relief in divorce cases. Indeed, the most pressingly, ancillary matters such as child custody and maintenance will not be dealt with sensibly, and it's difficult to overestimate the devastating effect that this will have on children caught up in these disputes. Indeed, the psychological effects that can be brought on children when care is not taken in resolving these disputes can be deep and long-lasting. The justice system has a duty to protect the most vulnerable in our society. This was, of course, one of the founding principles of legal aid. But who is the most vulnerable in society? I would say our children must be the most vulnerable in society. Overwhelmingly, the impact that will be had on the most vulnerable members of our society will be catastrophic. People receiving advice on debt, housing, welfare, as well as children standing in the middle in these disputes. We must not allow these changes to be made. We cannot allow them to be made in the name of decency, in the name of ethics, and in the name of providing decent cover for those less able to look after themselves. And we must not hold such an integral component of our justice system as a hostage to efficiency savings. If we do so, the effects we will see will be brutal. Finally, I ask the Minister to respond to this point. I do hope that this consultation will be a real one. The one on court closures left me underwhelmed. It was deeply unimpressive, flawed and probably pointless.
Thank you, Mr. Speaker.
It's a privilege to contribute to this debate today, and I want to specifically talk about the impact upon rural areas and in my own constituency of Aberconwy in North Wales. But I'd also like to associate myself with the comments of my honourable friend, the member for Broxtowe. I think a lot of what she said I would be able to replicate, but I would actually try and concentrate on the issues which are specific to myself in North Wales. I think one of the concerns that we have in North Wales, and certainly in my constituency, is that this will potentially be another attack on services available in rural areas. We are already in my constituency in a position where we have only one firm offering legal aid which is not based on the North Wales coast. So inland we have a single firm currently offering legal aid. And the truth of the matter is that this consultation would result in that firm giving up in that provision. And that would be a loss to the area in question, specifically because it would mean that people would have to travel in order to gain access to legal advice and legal services. And in this current age of very high fuel costs and so forth, this will be an added burden in order to allow people to even access services which might be available on the coast. So I think there is an issue and a real concern in rural areas as to whether this is again an indication of governments retreating from offering services across the whole of this country. But another specific issue which does affect my constituents in North Wales is the fact that quite often they will try and access services through the medium of Welsh. And I think this is a crucial point because I live in a constituency which is fully bilingual. On the coast we have 20-25% of the population who would speak Welsh as a first language, but inland the percentage would be significantly higher. And when people are dealing with real issues of concern, when people are trying to access support at critical times in their lives, the ability to access those services through their mother tongue is very, very important. Now, the impact assessment which has been produced has highlighted this issue in relation to services in cities in England and in South Wales, I'm sure. But I would want to ensure that the department is aware of the fact that there is an issue in terms of services through the medium of Welsh. And one of the concerns I have is that the consultation document talks about the need to provide a direct telephone line service. And I'm sure that my honourable friend, the member for Meirionydd Dwyford Meirionydd, I should say, would be well aware of the fact that whilst Welsh speakers often would prefer to have a service with the medium of Welsh, when it comes to accessing services via the telephone, there is almost a feeling that you have to pick up the phone and speak in English first. Whereas when the service is available in your locality, when you're able to walk into a firm which you know, recognise and have used in the past, you will be able to go in and talk to those solicitors through the medium of Welsh. So the fact that we are proposing offering so much of the legal aid services through the medium of a telephone line does raise real concerns in terms of a provision of a fully bilingual service in a Welsh contact. And then the other point I would like to make is that since I was elected back in May, I have been astounded, to be perfectly frank, as to how much casework I am dealing with, which is actually quasi-legal. I find myself in a situation where I'm dealing with cases where I'm not actually qualified to offer advice or guidance. Before coming into the chamber this afternoon, I did ask the question as to whether the insurance that I had as an MP would be sufficient to cover me for the fact that I would be asked to offer legal advice and guidance. And I have a real concern that as we are dealing with these significant changes to the provision of legal aid services, we are also looking at a significant reduction in the funding of Citizens Advice Bureau and so forth. And therefore we are in a position where we will end up, in effect, looking at MPs dealing with cases which are not actually qualified to deal with in a way in which would be very unsatisfactory to the individuals who are looking for advice and guidance, and very unsatisfactory from the point of view of an MP who can damage his or her reputation by offering advice and guidance which they're not qualified to do. But finally, I'd like to just close by stating that I do recognise the fact that the government has to deal with a deficit. And I'm very pleased that this is a debate on a consultation process. We are currently in a consultation process, but I would agree that that consultation has to be real. I will certainly be feeding into that consultation, as will many members of the law profession in my constituency. But my real concern is that we will end up, as a result of these proposals, in a situation, if they're not amended, we will end up in a situation where many parts of rural Britain and rural Wales will not have access to legal services. And in particular, I am seriously concerned that we will end up in a situation where some of the most vulnerable people in my constituency will find themselves in a situation where they'll have to access legal services through the telephone line in a language which is not their mother tongue. And that I would find to be unacceptable.
I remind colleagues that the front bench speakers will be called from 5:38 or thereabouts onwards, so there's real pressure on time. Mary Glendon.
Thank you, Mr. Speaker. First of all, I would like to congratulate my honourable friend, the member for Makerfield, on securing the debate. But unlike her, I don't have any experience of advice, of working in advice or in legal aid. Many years ago, however, I did benefit from the legal aid system when I successfully pursued maintenance payments for my daughter. However, the reason I'm speaking in this debate today, Mr Deputy Speaker, is because I was alerted to the government's proposed reforms by one of my constituents who practices as a solicitor in a well-respected law firm in Newcastle upon Tyne. She spelled out to me just how devastating these cuts would be for many of my most vulnerable constituents who now, or may in the future, have need of legal aid. The government claims it wants to be fair, removing the right to help with legal costs from those who need them in order to obtain appropriate representation when they are making a challenge under law is overtly denying those very people a right to justice. In fact, the chairman of the Bar Council, Nicholas Green QC, has described the cut as a shrinkage of justice. I, like many other MPs, have been contacted by a number of organisations on this matter, each one making a case for retaining the $350 million in the legal aid budget, and concerned about the range of areas being taken out of scope because of the huge cuts in funds being made towards 2014. The Law Society has stated that the civil legal aid scope cuts in social welfare law appear to be targeted against areas of law which are most relevant to the poorest and most vulnerable members of society. This is borne out by the information which I kindly received from the Director of the Citizens Advice Bureau, Mark Armand, that operates from across the borough of North Tyneside and serves the constituencies of both North Tyneside and Tynemouth. He advised me that cuts to legal aid are a double whammy, as the government has just announced the end of North Tyneside Citizens Advice Bureau's Financial Inclusion Fund from April this year. So with cuts to legal aid, North Tyneside CAB will lose 2.5 debt specialist posts, 1.5 benefit specialist posts, and the end of the Financial Inclusion Fund means 4.5 further posts will go. But last year, Mr Deputy Speaker, our CAB handled over 72,000 cases. The staff dealt with over £25 million of debt, not including mortgages, and managed to write off £4.5 million of this debt for local people. Furthermore, with work carried out on benefits this year, the Citizens Advice Bureau in North Tyneside is projecting benefit gains of nearly £900,000. In light of these figures, it's easy to imagine the hardship that will be caused by the loss of funding, which to date has made such a difference to constituents whose only avenue of help is via the legal aid route.
I'm most grateful for the Honourable Lady giving way. But can I just clarify the point with her? In the election manifesto in 2010, on which she stood on, her party committed to "We will find greater savings in legal aid" under paragraph 5.5. How does she intend to satisfy that commitment if she doesn't support the change this government's bringing into play?
Our shadow team are not denying that certain efficiencies have to be made, and in fact did commit money, as was said before, to help during the recession.
Will my honourable friend give way? The truth is, the problem with these proposed cuts in legal aid is they're wholly counterproductive. You may save money from the legal aid budget, but you will incur expenditure in other budgets. There are ways to save money in the Justice Department's budget, and I will touch on them in my remarks.
Mark Armand made it plain to me that the work carried out by the Citizens Advice Bureau with the help of legal aid funding definitely helps the most vulnerable, those whose lives are most chaotic, who have literacy and other language problems. Self-representation, as proposed in the bill, is a non-starter for this group of constituents. Furthermore, in relation to debt advice, private independent debt advisors are not the answer. The government's own study on private debt advice found over 80% of these businesses provide incorrect and inappropriate advice, often at a cost to the client. These private businesses refer clients to advisors who are, in fact, debt collectors. Does the government really want to impoverish the poorest more by directing them down this path? With regard to the proposed telephone helpline, again the most vulnerable would not benefit. In North Tyneside, it is estimated that less than 10% of Citizens Advice Bureau legal aid clients would, whether because of literacy or language issues, be able to access the system. Such a system could only be considered as an adjunction to the present system. The previous Labour government did make efforts to find savings through the work of Lord Carter's review, with the aim of always striving to protect social welfare law. We on this side of the House believe that savings could be found in other areas to continue that protection. As a director of North Tyneside CAP told me, that while losing jobs and expertise is a massive problem, the biggest regret he has is that the changes to legal aid will fail clients. The coalition government needs to take heed of this debate and of the many experts who are making the case for the 500,000 people who will lose out as a result of these cuts. These cuts are not fair and definitely not just.
Rudd.
It is interesting to observe that in the remarks that members on both sides of the House are making today, we're not talking about lawyers. As the member for Makerfield has said in her opening remarks, it's more often about trained, local, part-time and sometimes voluntary advisers who step in to help the vulnerable in need of advice. They work in the Citizens Advice Bureaus or in other organisations in the voluntary sector, and in my opinion, they are a rare example of legal providers, though not lawyers themselves often, at a low cost to the public purse. Now, I accept that there are reductions necessary in the expenditure and in the deficit that is costing us, as we know, 120 million a day, a point well made by the member for Broxtowe. I'm sorry that the member for Exeter is not in his place. I'm sure he would challenge me on it. We could have an interesting debate. But since there's only a few minutes left to each of us, I will plough on. The problem with these cuts, I believe, is that they will be expensive in the long run, and that they do not do what this coalition has set out to do, which is to protect and help the vulnerable as they are set out at the moment. I represent a town wonderful in many ways in Hastings, but also deprived in others, with high unemployment at 5.6% against UK of 3.5%. And we need the support of agencies to give the advice to those in low income and the unemployed. In my town, the agencies have formed a consortia to win social welfare contracts, and they have vocal and powerful advocates who have been to see me, represented particularly by Julie Eason and from the Citizens Advice Bureau, Dina Christodoulis, and they have convinced me of the need of the service that they are providing. The average rate and cost of what they provide for the clients is £200 or lower. Even if what they do takes 3 times as long, that is the cost. It is really good value. This is not the place for cuts. We need to make cuts, but I think particularly this area of the front line is not the place. We should not be taking social welfare out of scope.
To the Honourable Lady for giving way, and I'm finding myself in agreement with what she's saying. Would she accept that if legal aid is going to be withdrawn as a source of funding for exactly the kind of work she's describing, the government really must find an alternative source elsewhere?
I'm grateful for those comments, and the reason why I'm speaking up on behalf of my agencies in Hastings is exactly that I value the work that they do. I value the work that they do to help the vulnerable in Hastings, and I also make the point that, as has been made by several other members here, that it is not efficient to costs. So the member is absolutely correct. We need to find another source in order to continue to protect those services. The advice from these agencies is crucial to the clients. They cannot, in many cases, represent themselves. The agency that I spoke to have made it clear that, having kept the records, 56% are in long-term illness or disability, and 68% have long-term mental health issues. I am worried that some of my most vulnerable constituents may really struggle to manage their own casework and prepare for a tribunal hearing without the help of legal aid-funded services. Now, I welcome the simplified welfare system that this government is working on. Currently, the member for Chingford and Woodford Green has some excellent proposals which will be coming through, which I hope and believe will make the welfare system much more simple. But until it is there, we have to recognise the situation we are in and that errors are made, and vulnerable people who cannot represent themselves must be able to have some representation. The benefit of having agencies working with these clients is that they can also recognise where there is no case. If we entirely allow individuals to represent themselves, we will have a situation where some individuals may well clog up the tribunals. In fact, the agencies that do it now are very effective at discouraging people who do not have a case from going forward, so that only the cases that merit the sort of attention that they are seeking actually get it. In Hastings, for instance, the consortia that I referred to has not lost an appeal for a client for employment support allowance or incapacity benefit since April last year, which I think is testament to their right choice of clients to support and of their professionalism. Last year, they provided a service to around 20,000 clients in my area, and collectively they have over £270,000 of contracts, which represents over half of the advice sector in Hastings. Now, we all know that local government funding is under pressure, and one of the key elements of the funding that they provide is to citizens' advice bureaus. Given the cuts to local funding and these proposals, I am worried about the future viability of the agencies that do so much work. Their advice is critical in a town of above average needs. The social welfare contracts only account for 4.5% of the total legal aid bill. What they provide, early intervention, is critical. If we get involved, the advisors get involved early, they can stop it escalating, stop individuals getting to the stage where they may well lose their houses. I would urge ministers to consider the costs and the consequences of these proposed changes to legal aid. We need to find alternative sources to support these agencies if they're not going to get them from this source. And I would also associate myself with the comments made by other members here that otherwise members of Parliament who are not lawyers, like myself, are going to have to train up pretty quickly because of the size of casework that we are going to receive. Thank you.
And Albert.
I'd like to congratulate my honourable friend, the member for Macclesfield, in bringing forward this very important topic. I also wanted to say this, that for as long as I have worked in the community, legally aided lawyers and law centres have often been at the forefront of the fight for justice for marginalised groups of people who otherwise could not have made their voices heard. These were often groups of people that were not necessarily getting help from their trade union, their councillors or their MP, because very often lawyers can pinpoint issues because of cases coming to them before they come to the attention of politicians. And because I know that so many legally aided lawyers and so many practitioners who work in CABs and law centres are often lawyers of extraordinary dedication, I deprecate the tendency of governments of all colours, and my government was just as bad, to talk about the issue of legal aid just in terms of the money going to lawyers, and even to slide into talking about fat cat lawyers. Since the Carter reforms, nobody, I can say with confidence, nobody makes a fortune in legal aid law practice, and I can hear members on both sides supporting me in that.
The Honourable Lady giving way. Prior to entering this place, I was a criminal barrister for a number of years, and to confirm what the Honourable Lady says, as a barrister ending up the Crown Court, you're there on £40 for a mention, you could be there all day. So the myth which goes around that barristers or lawyers, are fat cats, is completely wrong, and I support fully what the Honourable Lady has said.
Sadly, as I say, when governments of all colours consider legal aid, they seem to be zeroing in on the lawyers and the money they get, rather than the millions of people that they help. I also want to repeat what has been said on this side about the potential of these reforms to totally undermine the law centre movement. Nobody who has seen people queuing outside their law centre for help could support any action by any government which would undermine the law centre movement. I would also add that these reforms in legal aid will also undermine the practices of many high street solicitors who are often close to their community, helping their community. Disproportionate number of those high street solicitors are actually BME solicitors, and I don't believe the government has fully looked at how these reforms will actually undermine some of the structures of the provision of legal advice, help and support which communities rely on. A member said earlier that one of the reasons people have recourse to lawyers is the inefficiency of the DWP, the Department of Work and Pensions. I would add to that the inefficiencies of local councils, the inefficiencies of the immigration service, the inefficiencies and the unfairness sometimes of education authorities. But what are we to do? We acknowledge that there are systemic inefficiencies in many parts of the public sector. Are we going to leave tens of thousands of people to suffer injustice and unfairness to save money in the short term on the legal aid budget? I wanted to speak as well about this question about the limits of phone advice. Talking down a phone may be well and good for people in the wealthier areas of the country, but in the inner city, too many people do not have English as their first language. If English is their first language, they are inarticulate, they are afraid, they are inhibited. In 20 years as a Member of Parliament, I've had to offer advice to hundreds of thousands of people, and very often people come in, they mumble some issue or the other, and it's only after careful questioning, looking them in the eye, showing them you're sympathetic, they eventually tell you what their real problem is. You submit these people to talking down a phone, their issues will get completely lost, they will put the phone down, never having explained what it was they really wanted to talk about.
I'm very grateful to my honourable friend, although in many ways her constituency and mine are very different. One similarity that has been commented on repeatedly over the years is that they both share high levels of deprivation. And will she agree with me that take away access to organisations like Kirby Unemployed Centre, Merseyside Welfare Rights and Knowsley Citizens Advice Bureau, those levels of deprivation in her constituency and mine will go up?
There is no question, because we're not talking about frivolity here. We're not talking about serial litigants. We're not people that litigate for fun. We're talking about people who find themselves having to go to law to get the basic rights and fairness that the rest of us, that those of us in this chamber take for granted. So, I mean, the question of picking up a phone for people, for communities in the East End of London. I mean, ministers are not realistic. They cannot understand what happens in some other country if they think that going on the phone is a substitute for dealing with somebody that is skilled, somebody that is looking in the eye, somebody that can see that you're nervous and knows how to put you at ease and really draw from you what is the issue that is at the heart of your problems. Now, we understand on this side of the House that there is a need to look at the budget of the whole administration of justice. I personally think there was a lot to be said for encouraging people with marital disputes to try mediation first rather than going to law. I've never heard of a divorce case where tempers were sweetened by the involvement of lawyers. So I don't reject the notion of encouraging people in marital disputes to go to mediation out of hand. But there are other ways that you can save money in the Justice Department budget, notably the organisation of the courts. Hundreds of thousands of pounds is wasted every year when cases collapse because people don't turn up, it's not being organised properly. Let us look at saving money through the organisation of the courts before we look at these ill-thought-out cuts in legal aid. Members opposite have raised the issue of the NHS, admitting liability earlier and saving all the costs in contesting cases where really they know perfectly well in the end they will have to settle in some form or fashion. It is not enough for ministers to talk about, you know, Labour spent all the money, this is why we're doing it. And what ministers have to understand, that if you're serious about a big society, if you're serious about actually the role of government, we have to make sure that the most deprived and the most marginalised communities have minimal protection, and part of that minimal protection in my mind is access to justice and the rule of law. So I sincerely hope, on behalf of my constituents, on behalf of the Hackney Law Centre, a tremendous organisation, that this is a genuine consultation and ministers will listen to some of the things they will hear in this chamber this afternoon.
Buckland.
I'm very grateful, Mr. Speaker. May I echo the comments of the Honourable Lady, the member for Hackney North and Stoke Newington, in her proper analysis of the issue. This is not about lawyers, this is about access to justice. Yes. And I'm glad to see the Minister agreeing with those sentiments in the sense that this government is not indulging in character assassination when it comes to those practitioners in law. Now, There have been some excellent contributions, and I pay tribute to the Honourable Lady, the member for Makerfield, for getting this debate the time that it deserves. I wish there was more time. 5 minutes can hardly do it justice. I was happy to support her in her bid. It was also a pleasure for me to take part in the Westminster Hall debate that was sponsored by the Honourable Lady, the member for Westminster North, who took part earlier. And the points that I made in that debate are not points that I propose to reiterate today. But can I put on the record my thanks to the Department for having answered some of the questions that I've been tabling about the breakdown of the costs of civil legal aid for the last year that figures were available, namely 2008-2009. And that figure of £24.7 million in legal help for welfare benefit cases, as alluded to by my honourable friend, the member for Broxtowe, is a startling one. And it's one that I think that we should pay very close attention to indeed. There is no doubt, and it is a point that has been made by other members today, that there are real deficiencies in the decision-making processes when it comes to benefit entitlements. And I am utterly convinced that that large amount of money could have been saved if the process itself was far more sound. And I urge the Minister to work as closely as he can with the Department for Work and Pensions to make sure that they start to take a share of the burden here when it comes to the cost of representation. I can't take interventions because I want to make sure that other speakers have their say. I'm sorry on this occasion. As I've said, so much to talk about, so little time. Can I just pray in aid the Wiltshire Law Centre in my constituency of South Swindon, which does debt, welfare and housing work? Putting it bluntly, they are set to lose the vast majority of their income if these proposals take place. Can I put in a plea that the Minister work as hard as he can with all agencies of government to make sure that places like the Wiltshire Law Centre get some form of block funding to ensure that their valuable work continues? It is as fundamental as that. If we lose that service, I am worried that my constituents will have to travel a very long distance indeed to get legal aid help, because most private firms in Swindon now do not offer the services offered by the Law Centre. I've made remarks in the past about SEN and education law. I again reiterate my plea to the Minister to make sure that when the Education Green Paper is published in March, that the alternative forms of dispute resolution, whether it be mediation or other forms of ADR, are properly explored and set out so that the need for legal representation in those cases becomes a thing of the past. Now, drilling down as far as I can as to why it is that this country spends more per head on legal aid than other countries, I note that the National Audit Office paper on the procurement of legal aid makes this observation, that during its control period, I think which was back in the latter part of the decade, we prosecuted over 1 million more people in England and Wales than any other country under comparison. Now, we've got to start looking at the reasons why we spend a lot on legal aid. I don't think that is a problem. I think that shows that the system, that we are taking prosecution seriously. But the point I want to make is that the only real comparison we can make is with other Commonwealth countries. And the fact is that those Commonwealth countries don't therefore bring as many cases as we do in England and Wales. Yeah. Comparisons with France, for example, are utterly irrelevant. The French, in fact, spend 5 times more on their judicial system than we do because of their inquisitorial process. So we must focus our minds upon comparisons with other common law countries. Yeah. I think the simple fact is that we litigate more in England and Wales. And as I've said, I make no apology for the fact that we bring more prosecutions in this country than any other. Those are issues that really need to be dealt with in other places, and that is a causal issue rather than the symptoms that we see that legal aid has to deal with. I wanted to talk about domestic violence. My plea to the Minister today is that we really need to work hard on getting that definition right. I would suggest that we haven't got it right in the Green Paper. We should be looking at courses of conduct rather than individual incidents, and I would welcome working with him on that in the future.
Yeah, well, thank you, Mr Deputy Speaker. Let me start by joining the congratulations of my honourable friend and neighbour, the member for Makerfield, for securing this debate on an issue that will adversely affect so many of our constituents. Mr Deputy Speaker, before Christmas, a woman came into my surgery in desperation. She was trying to extricate herself from a violent relationship, And as normal with such relationships, although she's now safe, her ex-partner continued to manipulate her and continues to exert his power by agreeing to things and then going back on his word. Even though she only earns around £20,000, she'd been turned down for legal aid and was in a terrible situation. She was paying for a solicitor, but had reached a point where she couldn't ask them to do anything else because she couldn't afford to pay them. As an ordinary person, she was terrified of running up debt, so she made sure that she paid all of her bills immediately, even though this meant that frequently she didn't have enough money to eat. And of course, celebrating Christmas was just totally out of the question. If the government goes ahead with its plans to reduce civil legal aid, my surgery is going to be full of people like this woman. Bolton Citizens Advice Bureau has sent a snapshot of one ordinary day at their drop-in. On January the 11th, their social welfare law drop-in was open for 6 hours. 63 new clients walked in off the streets. That doesn't include the other 31 clients who were coming back for return appointments. They say that if the current proposals to reform legal aid were implemented, and if the CAB's financial inclusion fund income is withdrawn, they'd only been able to deal with 5 or 6 of these people. And so many of these stories are heartbreaking, and very many of these cases had at least some element of benefits, either claims refused, delayed, or wrongly calculated. Many, like the lone parent with 3 children, who was only receiving £47.50 a week. Or the lone father who'd received no benefits for his 18-month-old and was told he'd have to wait another 4 weeks for any money. They didn't have enough money to feed themselves or their children. A number, because of failed businesses, were in imminent risk of losing their homes. Some had employment issues, others had immigration issues. But whatever the issue, the common thread was that these people came to Citizens Advice because they had nowhere else to go. They couldn't afford to buy legal support, unlike the people that were pursuing them for their debt or for not paying them their wages that they were due or refusing them benefits. Surely it's a mark of a civilised society that all people should have access to legal justice. Surely in 2011 we shouldn't be returning to the olden days when the poor simply had to accept what the rich and powerful did to them. And of course, if you're female or black or minority ethnic, the Equality Impact Assessment states that it would be more adversely affected. And it cannot rule out that there may be a disproportionate effect on the disabled. But the government doesn't appear to be taking any action to address this. My honourable friend has talked about the financial cost of removing legal aid. But what about the additional cost? What happens to the lone father who's getting no benefit? Does his child go into care? What happens to the person who loses their house? Do they go into emergency accommodation and then have to be rehoused by the state? And what about the long-term trauma of children caught up in this? Do they then fail in school and fail with their future life? This proposal is wrong, morally, ethically and financially. Mr Deputy Speaker, Citizen Advice Bureaus and community law centres are the government's big society in action. A combination of volunteers and professionals working in partnership to provide a service for their communities. Often the only service for those who are most disadvantaged. But like every other voluntary group, the service costs. Even if the projects are run entirely by volunteers, they still need funding for training and resources, premises and running costs. I won't argue to say that legal aid needs no reform, but this proposed reform is supported by no one. Even the most commercial firm of solicitors is saying it will have a detrimental effect on the most vulnerable in society. Please don't send us back to the days when justice was just for the rich and the privileged. I plead with the government to rethink their proposals.
Thank you very much, Mr Deputy Speaker. I had hoped to speak for about 25 minutes, but I see that I've got to cut it down 4. So I shall be very to the point and very abrupt. I want to make a plea, really, to the Minister of State. And I want to particularly make a plea about those lawyers who in fight against corporate bodies, local government bodies, who are under serious pressure to make serious cuts and sometimes get it wrong to the detriment of the most vulnerable in our communities. And I want to state a case to the Minister because I believe that the Legal Services Commission is already taking action to cut expenditure sizably, and we need to make the point that they shouldn't be doing it in rather the way they're doing it at the moment. let me talk about a company called Hossex, who are one of the 78 legal companies who fight on the basis of community and community services. They've done a tremendous job, and I've been on the wrong end of their job on occasions in the past, but they've done a tremendous job. However, in 2010, the Legal Services Commission, who had granted a contract to Hossex solicitors to fight a legal matter, said they had issued the contract in error. The company disputed that fact on the grounds that they had entered into a binding legal contract with LSC. LSC replied on the 6th of January, terminating the contract in its entirety. The company appealed and were told that the appeal would be heard within 2 weeks. They have now been told that it won't be heard until the end of March, when many of the budgets will be set and many of the cuts will be beginning to bite. And that is too late for the vulnerable people that they were going to represent.
Is the honourable member talking about a live case at this moment? Because
no, I'm not, because it's been stopped by the LSC. Thank you, Mr. Deputy Speaker. I simply want the Minister to look into this matter on the basis of how many more vulnerable people are being affected by decisions, I haven't got the time, I really haven't, by decisions taken by the LSC which are premature at this moment, bearing in mind that this debate has been going on. And I would ask the Minister to come back to me on this issue, because it does raise a very considerable concern affecting very many people throughout the country. And if LSC is acting prematurely, then it should be stopped until this debate is over and this consultation is finished. Mr. Deputy Speaker, I've got it within the time you wish.
you can take 2 minutes, you can, but you have to sit down at 5:35, please.
Thank you very much, Mr. Deputy Speaker. I'll start by congratulating my honourable friend for getting this debate in today. I'll concentrate the 2 minutes that I've got, if I can, on the Citizens Advice Bureau in my area. I met with the Chief Executive, Leslie Thornley, of my CAB on Tuesday, and she highlighted the very real problems that she thinks CAB will suffer. It seems to be a triple whammy. The Financial Inclusion Fund gone. 50% of the advice the CAB in my area provide is debt management advice. She's very concerned, as a result of that cut, what's going to happen to those people. Then the real terms cuts to legal aid is the second issue that CAB is facing. And then the cuts to the local authority. 42% cuts, she tells me, to CAB. And she highlights the fact that the Birmingham CAB is closed as a result of cuts, and worries very much that the CAB in my area will be cut and closed as a result of these cuts. I've spoken on numerous occasions to solicitors in my area. I spoke with Williamson solicitors, Mr. Wallington, very recently, and he tells me it really, truly is about access to justice. Publicly funded lawyers don't go into the job to earn big sums of money. Right. Teachers don't go into teaching to earn vast sums of money. So it really is about access to justice. And I just want the Minister to ensure that he looks very seriously at this. People, vulnerable people, will suffer as a consequence of the government's programme.
Does not count against you as far as the number of times that you've spoken. Mr. Slaughter.
Thank you, Mr. Deputy Speaker. May I start by congratulating the Honourable Member for Makerfield for securing this debate. Today has been an excellent example of how backbench debates can focus on an issue that is causing great concern in constituencies around the country. We've heard many good speeches today from both sides of this House, and it's appropriate that members from both sides speak in defence of legal aid. It was on the recommendations of a committee headed by a Conservative peer, Lord Rushcliffe, that legal aid was first proposed in 1943, and it was the Labour government and a Labour Attorney General, Sir Hartley Shawcroft, who piloted the Legal Aid and Advice Act through Parliament in 1949. The Secretary of State says that he wishes to return to the original intent of legal aid. Well, the original intent of legal aid was captured in paragraph 40 of Magna Carta. To no man shall we deny, sell or delay right or justice. And those were the very words that Sir Hartley Shawcroft had in mind when he said of his bill at its second reading, "It is a bill which will open the doors of the courts freely to all persons who may wish to avail themselves of British justice without regard to the question of their wealth or ability to pay." The government's plans in its Green Paper present themselves as a return to the founding intent of legal aid, but they're in fact the exact opposite. They will remove the average person's ability to seek justice. And in my speech today, I wish to focus on the cuts that I believe will cause most damage, those to social welfare legal aid. That is not to say there aren't problems with other aspects of the government's proposals. The narrow definition of domestic violence cases will leave women and children vulnerable and less able to seek help. The failure sufficiently to address the costs of very high-cost criminal cases is a mistake and a missed opportunity. And taking clinical negligence out of scope, alongside proposed changes to civil litigation funding, will end the ability of many people to challenge negligence and malpractice. But it's the cuts to social welfare legal aid that we find most unacceptable. They will result in the complete collapse of the social welfare advisory sector, and they will do so, ironically, at huge cost to the state. Let me, in the short time I have, give 5 reasons why these cuts are wrong. First, the advisory sector will all but disappear. The government proposes to eliminate almost all legal aid for social welfare: debt, housing, education, welfare, employment, immigration. They will cut funding for many advisory services like Citizens Advice Bureau and law centres. I will.
Very briefly, I thank my friend for giving way. Is he aware that an application made to the High Court this week was found in favour of the Mary Ward Centre and other voluntary organisations who were threatened with a huge cut by London councils on the grounds that there hadn't been an adequate equality assessment made in advance of these cuts? And this is a taster of what is to come if the government tries to put these cuts through.
Absolutely, and I pay tribute to Mary Ward, which I visited recently with the Noble Lord Berke and many other law centres around the country who do sterling work. But the cuts to law centres and CABs come alongside cuts to the Financial Inclusion Fund and local authority funding. If I may mention Hammersmith and Fulham Community Law Centre, where I've been a member of the management board for 20 years, it has lost all its local authority funding and will, if the government's equality impact assessment is to be believed, now lose 90% of its LFC funding. Most of the law centres around the country and many CABs and private firms will be forced to close. The remaining CABs will find their ability to provide services considerably diminished, particularly in areas of greatest deprivation. The loss of knowledge, talented advisors and a high-quality service provided at far below the market cost will be irreplaceable. The second point is that the most vulnerable will be hurt at a time of great economic turmoil. Consider the people served by the organisations I've just discussed. The Ministry itself estimates that 85% of legal representation and 80% of legal help are for individuals within the bottom income quintile. People with mental health problems and other disabilities experience much higher rates of unemployment, debt, homelessness and discrimination, and will therefore be disproportionately affected. The disabled are twice as likely to live in poverty as the non-disabled. And according to Mind, many callers are profoundly distressed and unable to explain their problems clearly. They find it traumatic to discuss with a stranger over the phone, and they need face-to-face contact. Thirdly, the government overstates the ability of people to navigate the legal system without advice or guidance. The Green Paper misrepresents the reality of tribunals and ignores the fact that the law is ever-changing and highly complex. Without specialist advice, many claimants will be unable to prepare a case for first-tier, let alone upper tribunals. Representation before court and in court streamlines the legal system and makes it more efficient. These cuts will deepen the existing inequalities of arms and lead to injustice, and also to great inefficiency in the civil legal system. Without representation, appellants are more likely to request an adjournment, get things wrong, achieve less fair outcomes, and therefore go on to further appeal, all of which causes delay and costs. Fourthly, the alternatives suggested by the government are inappropriate or inadequate. The Minister says that people should seek advice from tribunals or respondent organisations themselves, or the pro bono sector. The first two of those options have been greeted with incredulity. As for the last, this is what the Free Representation Unit, the largest pro bono organisation in the UK, said in response to the Green Paper. We should point out it gives a misleading impression. It wrongly uses the role of FRU to support its conclusions. The work that FRU does can be no part of the justification for withdrawing legal help in this area. FRU is in no position to replace the invaluable work of publicly funded solicitors, law centres and Citizens Advice Bureau in giving initial advice. They're right, Mr Deputy Speaker. The pro bono sector cannot exist in its current form without the infrastructure of the advisory sector. The fifth and final reason why these cuts are wrong is that the government's sums just don't add up. People who cannot resolve their problems often accumulate more problems and end up in cycles of decline. Social exclusion, eviction, unemployment, stress and depression, relationship and family breakdown. Children whose families are experiencing social problems are more likely to become involved in truancy, exclusion and offending. Early resolution saves time and money, identifying meritorious cases to take to court and preparing clients appropriately and settling out of court where possible. Once someone is already homeless, it costs the state tens of thousands to get them out of that situation. Government figures show that just at first-tier tribunal stage, had the proposed cuts been in place last year, over 51,000 cases that were successful would not have been, due solely to the lack of advice and representation. Mr Deputy Speaker, the Green Paper is filled with inaccuracy, imprecision and outright fallacy. The sums don't add up, and it will lead to the disastrous loss of many of the CABs and law centres that are the last line of defence, to quote, if I may, the headline from the Honourable Lady from Maidenhead's excellent article in The Guardian today, the last line of defence against catastrophe for the tens of thousands of people they help every year. Yesterday, someone who spent much of their professional life providing legal assistance to those that cannot afford it said to me, "Why has no one yet put this question in terms of the rule of law? A civilised society is one that encourages its decisions to be challenged, that understands that no decision can be beyond reproach. The legal aid system ensures citizens can seek and gain justice. Their lives are not placed into turmoil simply because they lack the means to challenge the decisions of large public and private corporations. That is the question that should haunt anyone that seeks to make such devastating cuts to a service that rightly makes us proud. To those outside this chamber who have dedicated themselves to helping the most vulnerable navigate an often bewildering legal system, let me join with many of my colleagues in thanking them for all they do for our country. They are the embodiment of the kind of civil society Labour has believed in for so long. Many give their time for free. Others have accrued decades of valuable experience with unique insight into the communities they serve. And I encourage them all to make their voices heard, because if their voices aren't heard now, and if the stories of those they help aren't heard, then this government intends to silence them forever.
Exactly.
They should be assured that we, on this side, will stand alongside them. Our voices will join with theirs. And together we will resist these sheer acts of vandalism.
Very good. Thank you, Mr. Speaker. And I should first like to congratulate the Honourable Member for Makerfield for securing this important debate. And we've had many excellent contributions from many honourable members this afternoon. It has been helpful to hear firsthand from those who have contributed today. And before responding on some of the specific issues raised, and there were many, I would like to reiterate the rationale and context of the reform proposals. And I should say at the outset that the Government strongly agrees with the views expressed by many here today that access to justice is a hallmark of a civilised society, and that the provision of legal aid in a targeted, focused and sustainable way is a key part of ensuring appropriate access to justice. So I say to the Right Honourable Member for Dwyfor and Hackney North and Bolton West that the aim here is to direct our scarce resources at helping the most vulnerable. And as honourable members will know, this government has pledged to reduce the budget deficit to deal with the acute financial crisis and encourage economic recovery. The Department has to reduce its budget by £2 billion by 2014-15, legal aid being one of just 3 big areas of spending in the Ministry of Justice needs to make a substantial contribution of £350 million to that reduction. However, the need to make savings gives us the impetus and urgency for change and provides us with the opportunity to radically reform the system that in many cases needs reform in any event. And to that extent, I do agree with the Honourable Member for Exeter that our policy cannot simply be determined by dealing with the deficit. In June, we announced that we would be taking a fundamental look at the legal aid system. Our aim then was and remains now to create a stable and sustainable system that ensures access to public funding in those cases that really require it, the protection of the most vulnerable in our society, and the efficient performance of our justice system. This also reflects the aim of creating a more efficient legal aid system as set out in the coalition government document. The position is that since the modern legal aid scheme was established in 1949, its scope has been widened far beyond what was originally intended. By 1999, legal aid funding was available for virtually every type of issue, including some which should not require any legal expertise to resolve. I would love to give way, but I have to say, with so many points having been made, I'm just not going to be able to, so I do apologise. I believe that this has too often encouraged people to bring their problems before the courts, even where the courts are not best placed to provide the best solutions, and discourage them from seeking simpler, more appropriate remedies. But do let me take this opportunity to congratulate my honourable friend on her excellent article this afternoon. Indeed, the scheme now costs over £2 billion a year, making it one of the most generous schemes in the world, even taking jurisdictional differences into account. And we need to understand that even after the proposed reforms, we're still going to have one of the most expensive schemes in the world. The previous government made many attempts to reform legal aid, conducting more than 30 consultations since 2006. But the changes were of a piecemeal nature and failed to address the underlying problems. Rather than continue with this cut-and-come-again approach, we have gone back to basic principles to make choices about which issues are of sufficient priority to justify the use of public funds, subject to people's means and the merits of the case. But whilst on the opposition, I have to say, Mr Deputy Speaker, that the opposition's general position on legal aid is staggeringly inconsistent and opportunistic. Labour appear to be backing down on their commitment to support legal aid reform. In an article for Left Foot Forward, the Shadow Justice Minister, the Honourable Member for Hammersmith, says it is nonsensical, he says, to cut these long-established public services. The article seems to reveal a split between the Shadow Justice team and their party leader, who said at a recent press conference that with regard to reductions in legal aid, Labour has shown it is ready to make difficult cuts, which we believe are necessary for the long-term health of our economy. Their leader was, of course, reiterating the promise made in the Labour Manifesto 2010 that we will find greater savings in legal aid. It also contradicts, I have to say, the Right Honourable Member for Tooting's own statement offering support to the government when the reforms were announced last year. He said, "Let me be clear, had we been in government today, we too would have been announcing savings to the legal aid budget. That is a reality that we all have to acknowledge." I think I do have to give way on this one.
I think he does, because now that he's read out the Central Office brief on the issue. But could I just urge that he either reads the Shadow Lord Chancellor's article in the Solicitor General today, or even my speech in the Westminster Hall debate, which he would have heard had he turned up to that debate before Christmas. In which case he will see exactly where we would cut, and that we have been clear throughout that we would not cut essential social welfare legal aid.
It's pleased to hear some clarification as what he's not going to do. Perhaps he's going to come back to the House and say what he is going to do, so that we can take some sort of view as to where the opposition is coming from on this issue, which has been thoroughly unimpressive to date. No, I won't. The proposals in our consultation paper do take into account the importance of the issue at stake, the litigants' ability to present their own case, the availability of alternative sources of funding, and alternative routes to resolving the issue, as well as our domestic and international legal obligations. I should also say that the consultation is still open, and I'm therefore here to listen to honourable members' views rather than agree or disagree with any particular views. We propose to focus financial support and legal advice and representation on those who need it most, and so the proposed reforms involve significant change to the scope of legal aid funding. Having said that, I should be clear that we are not proposing any changes to the scope of criminal legal aid, and legal aid will also still be routinely available in civil and family cases where people's life or liberty is at stake, or where they are at risk of serious physical harm or immediate loss of their home. For example, I can confirm to the Honourable Lady for Westminster North that we plan to retain legal aid for asylum cases, but not for immigration cases except when in detention. It shall also be retained for debt and housing matters where someone's home is at immediate risk and for mental health cases. It will still be provided where people face intervention from the state in their family affairs that may result in their children being taken into care, and for cases involving domestic violence, child abduction or forced marriage. We also propose that legal aid should remain available for cases where people seek to hold the state to account by judicial review for the most serious claims against public authorities. We should also keep it for cases involving discrimination that are currently in scope, and for community care cases where the recipients are often elderly and vulnerable. Now, many honourable members mentioned the question of telephone advice. And I should say that although it is a gateway, it will not stop face-to-face advice where that is appropriate. But it will facilitate, we believe, more effective sourcing of services and will help the disabled. And, as is currently the case, one can be asked to be called back, so the cost would be low. Also, for my honourable friend for Aberconway, let me tell him that the telephone advice, we do believe, will assist in rural areas, and language translation is catered for, particularly for Welsh speakers. And I should also say that this service currently has over 90% satisfaction ratings. So we see it as a very good service. We recognise that there will be some cases, even within the areas of law we propose to remove from scope, which international or domestic law will require to be funded by the taxpayer, or inquest cases where there is a significant wider public interest in funding legal representation. We therefore propose a new exceptional funding scheme for excluded cases. We also consider that too often the long drawn-out acrimonious nature of court proceedings exacerbates disputes rather than solving them. Very often there exist alternatives that are not only cheaper than rushing to court, but which are faster and less contentious. So we will continue to provide funding for family mediation to encourage people to use this more effective method to resolve issues between themselves rather than using up precious taxpayers' money and courts' time. Of course, mediation is only one alternative option to court proceedings. Work is going on across government to change our litigation culture and encourage alternative and less acrimonious dispute resolution. For example, the government is currently seeking views on measures to achieve more early resolution of workplace disputes through ACAS conciliation, so that all parties have a chance to resolve their own problems in a way that is fair and equitable for both sides without having to go to an employment tribunal. Likewise, the Department for Education are looking at involving parents in early discussions and decisions about the special educational needs support they need, rather than them feeling like they have to battle through the tribunal process. I think it was the Honourable Member for Westminster North who said that 82% of appellants in SEN matters succeeded in her appeal. But I should point out to her that just 18% of parents are currently legally represented in those appeals. On eligibility, we are not changing the criminal means testing brought in by the last government. But in civil, we believe that those able to pay for or contribute to the costs of their case should be able to do so. This will help ensure continued access to public funding in those cases that really require it, for those who have little funds or no funds of their own. The consultation paper therefore includes the proposal that all clients with £1,000 or more of disposable capital should make a minimum £100 contribution to their legal costs, and that the capital of any prospective legal aid clients is taken into account when considering eligibility. We believe that this will encourage a greater sense of personal responsibility by giving clients a greater financial interest in the conduct of their case, as well as helping to discourage unnecessary litigation at taxpayers' expense. Many honourable members, including those from Makerfield, Westminster North, Exeter, North Tyneside, Hastings and Rye, South Swindon, Kingston upon Hull, have raised points around the highly valued not-for-profit sector. I do understand, having met many times with CAB, Shelter and other voluntary groups, that the not-for-profit sector have particular concerns. But the important point is that this issue goes way beyond legal aid. Indeed, funding from legal aid represents the minority of many CAB's income. We believe only about 15% of CAB's income comes from legal aid. And many CABs do not receive any legal aid at all. The 3 CABs in my own constituency, for example, receive no legal aid money. This is because the basic role of CABs is to give general advice, not necessarily legal advice, as they have been allowed to do only for the last 11 years. The problem, however, for those that do give legal advice is that legal aid funding will often merge with other funding streams. In the case of CAB, they are funded mainly by local councils and biz centrally. And to remove one stream, I do appreciate, could have a knock-on effect. But that does not make it wrong for us to be unwilling to pay legal aid for general advice. The reality is that for years these funding streams have been in conflict, and effort and services have been duplicated and resources wasted, although the last government never sorted this out, whilst their money machine was simply pumping away. We have seen this problem, and I'm pleased to say to honourable members that we are working closely with the Cabinet Office based Office for Civil Society on this, who are looking at this important issue across government. And yes, transitional funding may be available, to answer my honourable friend for Carshalton. We do certainly see an important role for not-for-profit organisations in the advice sector. The coalition government supports not-for-profits, including CABs, and as my honourable friend for Broxtowe said, we hope that local government will share our view that they play an integral part in civil society. I'm happy to look at the issue raised by my honourable friend for Northampton South. The honourable member for Makerfield and Westminster North, Hastings and Rye and others spoke about welfare benefits. We recognise that some people find publicly funded legal advice on welfare benefit matters helpful. However, it is the case that the user-friendly nature of the tribunal means that appellants can generally present their case without assistance. But more particularly, these issues are normally ones that should be dealt with by general advice, not legal aid. When I visited a law centre recently, I was shocked to hear that local benefits officers were sending people to the law centre for advice on what benefits they could claim. This is a bizarre situation. That is not going to be solved by throwing legal aid money at the problem. And I'm afraid to say to honourable members that I have run out of time. This debate is going to continue. The consultation will continue. We are looking forward, I say honestly, to receiving honourable members' consultation responses and those from all respondees.
I'd like to thank all the honourable members who spoke. There were some good and passionate points made on both sides. Legal aid has been called the fourth pillar of the welfare state, and I urge the Minister to listen and take on board some of the points that have been made and not cut into it so deeply that the whole building collapses, leaving honourable members to pick up the pieces in their surgeries.
The question is, as on the order paper, as many as are of that opinion say aye, of the contrary no. I think the ayes have it. The ayes have it.
I beg to move that this House do now adjourn.
The question is that this House do now adjourn. Mr Anasawa. A point of order, Mr Russell.
Mr Deputy Speaker, the Independent Parliamentary Stands Authority, whose leadership heads the most incompetent quango in the country, has today published a name and shame of members of Parliament who, in their mind, have made claims to which they were not entitled. Amongst those names is myself. What I have to tell the House is that the payment was paid to me in full on the 13th of December. IPSA knew that. They took 2 months to pay it, admittedly, but they acknowledged that the claim was a legitimate one and it was paid. But my name appears in a list of those who had a claim refused. Mr Deputy Speaker, what action can be taken by members who have been maligned, one would argue sort of libelled and slandered? What action is there available to members of Parliament against this incompetent organisation?
Well, I believe that you are a member of the Speaker's panel on IPSA, and I'm almost tempted to ask you to refer it to yourself. But I won't do that. He knows that this is not a procedural point for the Chair, but has put his views on the record, and he will know that there are other ways of taking this point further.